Yeah, good evening, everyone. Thank you very much for joining this evening session on MIAD. Ask questions and likely questions that are common in examinations. Before that, I've sent a pass. From there, we'll try to trade some questions. Please, can you see me? Just want to be sure if you can see me.
I can see you.
Thank you very much. Now, the first thing I want you to look at is I want you to read. If you see the past question I dropped in the group, please open it. Look at question number one. Look at question number one at the past question. I want somebody to read question number one for me. Anybody to read question number one for me, please? Anybody to read question number one for me? The past question I dropped in the group. Please let it be interactive, please.
Is it the one that has answers attached?
Oh no, the one I dropped in the group now. I dropped something in the group not quite long. Not up to 10
Okay,
minutes. I
can I?
dropped something in the group. Yeah, you can.
Okay. It says the primary aim of international law is to promote international peace and security. Discuss using the subjects of international law as a point of reference. That's question
So we
one.
says the primary aims of international law is to promote international peace. The primary aims of international law is to promote international peace and security. They are now asking us, we already know it's to promote international peace and security, but they are asking us to use the subject of international law as a point of reference to explain it. Listen, they're asking us to buttress that statement. The first statement is and security. That's the first statement. They are now asking us to buttress that statement using the subject of international law. Now, when you look at this question, I want you to look at the second past question. Look at question number one of the second past question. What does it say?
It
Please, I want
says
it to be
the
interactive.
the ultimate objective of international law is to promote international peace and security. Discuss.
Thank you very much. The ultimate
The
objective of
ultimate
international law
objective.
is to promote international peace and security. You should discuss. You see, this question number one in this past question and with the first one are similar, but how they put it is different. Listen, the first one they asked us to use the subject of international law to discuss it, while the second one they did not mention a point of reference to discuss it. Now, look at the third past question. The third past question. The third past question. What is question number one of the third past question says? The third past question.
The ultimate objective of international law is to promote international peace and security. Discuss the recent Russian-Ukraine crisis as a point of reference.
Thank you very much. You will notice that the first question, the second question, the third question you are reading out are similar. But the difference with the third question is that they are now using Russia and Ukraine as a case study, which means that there are likelihood that they use Iran and Israel crisis as a point of reference. There is likelihood that they use that one as a point of reference. So this question of international law as the objective of promoting peace and security, we should discuss them, has been repeating itself year in, year out. So that is why our first point of contact today is going to be that particular question. So how are we going to answer that particular question? If you look at the question number one, they say we should use the subject of international law. The subject you read say we should use the Iran. So they still mean the same thing. So we are going to look at them one after the other. Now, the primary aim of international law is to promote international peace and security, discussed using the subject of international law. Discussed using the subject of international law. So one thing we need to understand is that when we talk about international law, we need to know that international law is a system of treaty and agreement between nations that govern how nations interact with one another in international system. Now, we are now asked to look at this question. If you are asked to look at this question, we need to look at the subject of international law and the promotion of peace. So when we say the subject of international law, as in we mean the entity possessing international rights and obligation. Understand? The entity possessing international rights and obligations and having the capacity to maintain it by bringing international claim and to take responsibility for its breach of obligation. So while we are trying to examine the subject of international law, we need to look at what do we mean by the subjects. What are the subjects, rather? What are the subjects of international law? Number one subject of international law is the state. Because there is no way you will define international law itself that you will not mention the state. Because it's one state, two state, three state that makes a component. So without state, we cannot have an international law. So state remain the primary subject. The state, country, country. So the country or the state remain the primary subject of international law. So what is a state? Let me just put it to you like that. What is a state? Anybody to help us? We've done that in first semester. What is a state? What is a state? I'm not saying by Oyo State or some state or Lagos State. I mean, in this context, what is a state? Anybody? Please, I want it to be interactive. What is a state?
A state is a sovereign political entity.
What is a state?
A sovereign entity.
Okay. A state is a sovereign entity. Okay. Okay,
if
I'm with you. Is that all? A state is a sovereign entity. Yeah, a state is a sovereign entity. She's right. Listen. What?
Can I add?
Yeah, sure.
Hello, can you hear me? Okay. As she said, it's a sovereign entity with defined territory, with permanent or stipulated population. I think there are three major things: geography, population, territory, and sovereignty. In a nutshell.
Okay. It has 4 characteristics. It has a population, the territory, the government, and the sovereignty. So a state is an organized political community acting under a government, possessing 4 characteristics: population, territory, government, and sovereignty. Understand? The sovereignty that she mentioned in the first definition, the sovereignty is the absolute power of a state within its territory. Understand? Within its territory, the absolute power the state has without the interference of both internal and external control. Understand? Now, answering that question number one, the subject of international law. And we now say that state is the number one subject of international law. Understand? So Meaning that we need to we need to state how states also contribute to peace and security in international law. So the role of the state in promoting peace through international law is diverse. Understand? States enter into bilateral and multilateral treaty that codify the norms of peaceful conduct in the international system. They participate in international organizations that provide forum for peaceful dispute resolution, and they submit to jurisdiction of international tribunal for the peaceful settlement of dispute. Which means that if we are saying that Mina raise her hand, please, I might not see your messages. It's 8. I might not see your messages if you drop message. So I'll drop a message in the group. I say it's MIAD 814. MIAD 814. So please, I say it's MIAD 814.
Okay,
I might not see your message even now.
804.
What? 804. They say you have a class, so I say we are going to meet tomorrow.
My question is this class 814 or 80?
814.
Okay, 814. Thank you. Sorry. Thank you so much.
Okay, can we continue now? If you drop message, I might not check the message because I don't look at messages when I'm concentrating. So we are talking about the subject of international law, and we say the first subject is the first subject is the state being an important element in international law, and we define the state. After defining the state, we mention the role of the state in participating to or in promoting peace through the international system. We say that the state they enter bilateral and multilateral treaty, which brings a peaceful conduct. Understand? Because when you go into a bilateral or multilateral treaty, you remember that we say that countries that do transaction together are less likely to go into fight. So far as they go into bilateral and multilateral treaty together, that is a peaceful conduct. And they also participate in international organizations that provide a framework or a platform for peaceful dispute resolutions. And aside from that one, the state also submit to the jurisdiction of international tribunal for the peace settlement for the peaceful settlement of dispute. Understand? So if you remember, the state must respect the principle of pacta sunt servanda. Understand? The principle pacta sunt servanda, P-A-C-T-A, pacta, sunt, S-U-N-T, servanda, S-E-R-V-A-V-A-N-D-A. So the state must respect that principle. And what does that principle mean? Understand? The principle means that the agreement must be honored in good faith. Understand? Which means that if the state go into a bilateral or multilateral agreement or treaty, understand, they must respect that agreement. If they don't respect that agreement, they are going to submit themselves to the international tribunal. Understand? So, but if you are talking about state promoting peace, understand, they do not promote peace just like that. They promote peace even with tensions. What are you saying? Are you saying something here? So, in essence, what we are trying to understand, what we are trying to say is that the state remain a subject for promoting peace. Look at that question number 1 very well. Let me open my phone. I want to read the question number 1 for you to understand. They say that the primary aim of international law is to promote peace. International law is to promote international peace and security. Discuss using the subject of international law as a point of reference. The subject of international law. So we first define international law. After defining subject international law, we now mention the number 1 subject of international law, which is a state. Because without a state, there is nothing like international law. Without a state, we cannot have international corporations. Listen, that's number 1, the state. Why the second subject of international law is the international organizations. The second subject is international organizations. And when we say international organization, what is international organization? Anybody to help us with the definition, please? Anybody to help us with the definition? What is international organization? What is international organization, please? Anybody, please. Let us be interactive. What is international organization?
International organizations are formal institutions created by states and sometimes other actors.
So they are formal institutions created by states. So normally they might be created by non-state actors. They can be created by non-state actors also. So now, international organization remains the second subject of international law of maintaining peace, which means that the international organizations, both governmental, which is the IGO, and the non-governmental, which is the INGO, listen, they are regarded as a second subject of international law. Listen, they create a how do you call a platform for peaceful negotiation and dispute resolutions. Listen. So whenever there is crisis in the international system, they provide solution. They provide solution through the platform, especially in terms of international conflict, civil wars, humanitarian emergencies, irregular migrations, climate change, financial instability. They use the platform to provide solution to this problem. And looking at the international organization, the League of Nations was the first global political organization that was established to maintain international peace through collective security, disarmament, and arbitration. So, tracing the international law, the international organizations, mentioning the definition of international organizations and how they intervene or what they do to solve problem and which kind of problem they intervene to is what we need to look at in this aspect also. We talk about the state, we talk about the definition of the state and how the state also contribute to peaceful peacekeeping, or peace and security in the international system. We've moved out. We talk about the international organizations. Listen, we talk about international organization because the international organization also, without them, it's going to be difficult for countries to sit down in the platform to discuss. Listen. So at the international organization level, we have a major actor, which is the United Nations Security Council, which is responsible for international peace and security because it has the authority to investigate situations threatening international peace, recommend procedure for peaceful resolution, and impose economic sanction, even sometimes authorize military action through binding resolutions. In essence, we are trying to explain how the international organization also make their impact in promoting international peace and security. Do you understand? So at the international level also, if you are trying to explain that one, we also need to mention, because we've mentioned that we've talked about the definitions, we'll now talk about how they promote, how they maintain peace and security internationally. We mentioned the first organization, that is the League of Nations, how they also have the impact in maintaining peace. Listen, but currently, the United Nations Security Council is the one that make much impact in maintaining peace and security internationally. Listen, and aside from that one, we need to talk about the International Court of Justice. Listen, the International Court of Justice, they serve as a primary judicial organ of the United Nations, because they are there to hear dispute between countries. When there is dispute between countries, they are there to hear the dispute, and they are there to make decisions. Listen, so you are not defining the international organization only. You need to also explain to the examiner how they also make impact in maintaining peace and security. Listen, they make impact through the, how do you call, the United Nations Security Council. They also through the international, how do you call, court, International Court of Justice, ICJ. Listen, so you need to explain that one. This is the second subject in international law. The third subject is the individual. The individual. The third subject is the individual we are going to look at. You notice that law exists because we individuals, human beings, we exist. Understand? Law exists because human beings exist. Understand? If you look at the definition of a state, you will notice that in the definition of a state, we mentioned that there's populations, that population exists. Understand? Which means that the individual also, they have their own impact in maintaining peace and security, starting locally to internationally. Understand? The International Criminal Court, the ICJ we mentioned in international law. Listen, the ICJ we mentioned, they are there to protect individuals. So by creating individual criminal responsibility for any violation anywhere in the world, understand, this serve as peace promotions in the international system. If any country anywhere in the world violated the right, like how do I put it, like I want to look for one grammar, but like a mass violations of right of people that is glaring, that require the involvement of the International Court of Justice. Listen, so if the International Court of Justice exists, listen, to protect individual, listen, definitely individual also have an impact in promoting the peace, because we serve as a check and balance between the government or our state and the international community. If you see the right of people being violated anywhere and you report, and it is glaring that, okay, you can see sometimes on the internet with videos, the attention of how do you call, Amnesty International, or ICJ is called upon based on videos only. They are not there, but maybe somewhere around the world, just video something and they see it, they call the attention of the on people. Understand? So the international human rights framework established in the United Declaration of Human Rights has also point out how individual as a subject of international law is recognized both politically, economically, socially, culturally, how they are recognized and how they are protected internationally. So the protection of human rights, the protection of human rights or the protection of individuals contribute to international peace by addressing the fundamental injustice that often serve as the root of conflict. Which means that if we say that there is an international court that protects countries in time of dispute, but you should know that a country cannot exist without populations, then there should be a law that protects people. And the law we are talking about is codified in the Universal Declaration of Human Rights of 1948. So this Universal Declaration of Human Rights of 1948 served as a primary protection for individuals in the international system by addressing injustice anywhere in the world. Because if injustice is not prevented, there is going to be conflict, and conflict that we are trying to curb. Listen, so that's number 3 subject. Number 4 subject of international law in this context is insurgent and national liberation movement. Insurgent and national liberation movement. So this insurgent and national liberation movement, they also occupy a complex position as a subject in international law. And when we talk about insurgency, we are talking about an organized movement aimed at the overthrow or the destruction of a government. Understand? It can be through espionage, armed conflict, terrorism, or anything you might think of. Understand? So sometimes we see them as illegal organization or illegal group, but they also have an indirect impact. Understand? They also have an indirect impact in promoting peace and security. So from a perspective of international law, understand, the insurgent group, they represent both a threat and opportunity. They represent both a threat and opportunity because they threaten the peace by weakening the power of the state. Doing so, they trigger humanitarian crisis, and if humanitarian crisis is if humanitarian crisis is triggered, listen, definitely the attention of the international community is going to be focused on that particular society or that particular country where we have the issues. Listen, so this brings the focus of the international community or international law on this insurgent group or the combatant or the insurgent group or the combatant. Understand? So by doing so, we try to look at what they want. Are we able to afford what they want? If we are not able to afford what they want, then we need to go on protecting people that are in that particular community. So recognizing this insurgent group as a subject in international law, let us understand that the state itself is threatened Although we say the state has the sovereignty, but sometimes the state is threatened by this insurgent or liberation group. So once they are threatened by this insurgent or liberation group, there is need for international community or international organization to come in to provide support to the state or negotiation where needed. So if support is coming or negotiation comes in, then it's going to facilitate the restoration of peace in that particular community where they exercise. So in essence, we talk about the state, the international organization, the individual, and the insurgent group or national liberation movement being a subject of international law in maintaining peace and security. There are more than that. There are more than that. It's not only these four. But we need what we need to understand is that for peace and security to be maintained internationally, there are many pillars that are involved. Not only the state, the international organization, the individual or insurgent group. There are many pillars that are involved in maintaining peace and security in international organizations. Another question they ask, we want to look at another question. The question says, critically examine alternative dispute resolutions in international law. Critically examine an alternative dispute resolution, ADR, the ADR in international law. How can we resolve disputes? How can we resolve disputes in international law? How can we look at the past question I sent you? Look at the second past question, question number 2. The second past question, question number 2. The question, anybody is here? Am I the only one here, please?
We are here.
Okay.
Yes, we are
When you look at
here.
the second past question I sent you, look at the document I sent you just not recent, not quite long. So question number 2, you look at the question number 2, it says we should critically examine the alternative dispute resolution in international law. Now look at question number past question number 3. Look at past question number 3. Question number 5. Look at question number 5. Look at question number. What is question number 5 saying?
Examine
Question number
the
5.
examine the various factors limiting the success of negotiation in international law.
No, not that one.
The
Past question number. The third past question.
Discuss
Okay,
the reasons why negotiation is universally.
Is the fourth past question.
Am I saying the right one?
Let me check. No, yeah. Okay, sorry. I'm the one that made a mistake. So is the fifth past question? Is the
Number
fifth
what?
past question? Number 5. The fifth past question number 5.
Okay, discuss 3 practical processes. Discuss 3 practical processes of alternate dispute resolution in international law.
So that is the ADR, alternate dispute resolution. If you look at this past question, you will see the ADR. The ADR as alternative or alternate dispute resolutions. These are common questions also. The ADR, the alternate dispute resolutions. So Alternative dispute resolutions. Alternative dispute resolution. So, and when we talk about alternative dispute resolution, what is alternative dispute resolution? And whenever we talk about alternative dispute resolution, what you need to understand is that from the word alternative or alternate dispute resolution. Listen. So they are this is any procedure agreed to by the parties to a dispute. Any party involved in a dispute, the procedure they agree to, in which they can use the service of a third party or a neutral party to assist them in reaching agreement or avoiding a formal litigation or adjudication. Look at what happened in recently between and Iran and Israel. You know, they have to go to, I think, Pakistan, if I'm not wrong. They have to go to Pakistan for solution. Although they did not agree at the end, but they have to bring in Pakistan to be the aid to be a, how do you call, a neutral party to assist them in reaching agreement. So which means that if the conflicting party, they are not reaching an agreement, they can both decide to call in a neutral party to assist them in reaching an agreement. Listen, that is the ADR. Listen. So rather than going, it happened even between two individuals. Those people that do law among us, we can testify between two individuals. If you have crisis, so the lawyer can even advise you that let us find a solution among ourselves before we take it further. So before you take it further and it's going to spend a lot of money, you can settle it amicably sometimes. Listen, so the ADR, the significance of the ADR in the international context is diversified in different ways. Listen, number one significance of the ADR or importance of the ADR is to preserve the sovereignty of the parties by allowing them to retain control over the outcome. Understand? To preserve the sovereignty of the party, which means that if both parties decided to involve a third party, it's not that they are relinquishing their sovereignty. No, they are just trying to put somebody to resolve the problem. Not that they are throwing away their sovereignty, they are preserving their sovereignty. And so, number two, it is number two important or significant of this alternative dispute resolution. And it is faster and less expensive than formal adjudication. Faster and less expensive than formal adjudication. Instead of us to go to court and spending money every time, we can call in a third party, resolve the issues. Although sometimes the third party or the neutral party might not even resolve the issue, which might lead to where you don't want it to lead to, but it's also less expensive and faster. Understand? Why the third significant or important of this ADR we are talking about, alternative dispute resolution or alternative dispute resolution, is it is conducive to the maintenance of ongoing diplomatic and economic relations. Because during war, diplomacy still continue. So if during war you have to pause war and call on a third neutral party or a neutral party to come and solve this dispute for you, anything the third party is doing, I have to rely on both the ongoing diplomatic or economic relation, which is also very important in international relations. So the question they now ask us is we should critically discuss the processes of alternate. That's the question. So we are just trying to explain the ADR for us to understand what the ADR is. So now, the ADR, the principal mechanism of ADR international law. Number one is negotiation. Negotiation. What is negotiation? Anybody, please? What is negotiation? What is negotiation? What is negotiation? Anybody? Anybody? What is negotiation?
Negotiation is a process where states and global actors discuss issues or resolve conflicts.
Okay. Negotiation, how we sit down to resolve conflict. Okay. Usually it's not only conflict, but it also works. So what we need to understand is that negotiation remain the fundamental or the widely used mechanism of ADR. When I say ADR, I mean the alternate dispute resolution. Listen. So it's taken as a preferred technique for resolving conflict. Listen. The preferred technique. It refers as a preferred technique for resolving conflict. How do we resolve conflict if we don't negotiate? If we don't talk? Please kindly mute this person. Zaina Mukhtar. Mute her. So the principal mechanism, we are talking about the principal mechanism of ADR, alternative dispute resolution. I was saying number one is negotiation, which means that negotiation is number one because you need to talk to resolve dispute or conflict. Listen. So with negotiation, it is less formal method whereby parties meet in good faith to discuss and address the dispute with the goal of reaching a resolution. Understand? Sometimes it can take place with or without lawyer or neutral parties. You will notice that before Iran and Israel will have clash, there was some negotiation last year, September, October, November month. There was negotiation between these two countries with USA. Listen. So it does not necessarily need the intervention of lawyers or neutral parties. No. Listen. So the goal was to reach a resolution. The resolution is to let Iran stop his process or his portion for nuclear weapons. That was then with the negotiation throughout last year. So negotiation is recognized as a primary mechanism of alternate dispute resolution because it is directly involved the parties involved, those that are disputing, those that are in crisis. It involves them. Listen, while involving them, they also put in consideration their sovereignty. They are not taking away the sovereignty because sometimes country might feel like they are taking away their sovereignty. No, they are considering their sovereignty. They are just coming in for a peaceful talk to reach a resolution. Listen. So at the United Nations Charter, it is stated that dispute should be resolved through peaceful means. Listen, and if dispute should be resolved through peaceful means, we should all know that negotiation serve as a first step. Listen, the first step before any other alternative dispute resolution mechanism can be involved. Before any other alternative options, negotiation have to come first. So after negotiation, we have mediation. Mediation process is where a neutral party or a mediator intervene in a dispute to help the party amicably and informally resolve the dispute. Listen, is when we put out a third party or a mediator to intervene in the dispute. Yes, sir. So this mediator will provide a platform for both parties to address the disagreement. Listen, without the cause of litigations. So in reality, when we are talking about mediator being involved in resolving disputes, listen, this mediator, they are trained individual. Listen, they are trained individual in negotiation. They work how to settle dispute in a way that both parties are going to come into a resolutions. So, in the context of international law, mediation has been used on several occasions. Listen, between Israel and Palestine, between Nigeria and Cameroon, between many countries. Listen, mediation has been used to solve dispute that is involving a third party to come in. Listen, so for a mediator to achieve its goals of resolving dispute, it's now going to depend of how neutral or how expert the mediator is. And also, not only depending on how expert or how good or neutral the mediator is, but how both parties are willing to engage in good faith. Understand? So Israel and Iran, they went to Pakistan last month to solve this dispute, but they were not able to solve it because both parties, although the mediator has a good faith to resolve this, but both parties were not ready to step down for each other. Understand? So this is the second mechanism of ADR. The third mechanism of ADR is the arbitration. But before I go, what is ADR? Because I know I've said it several times because people might not even know the meaning as I'm saying it. What is ADR? What is ADR?
Alternative dispute resolution.
Thank you very much. Thank you very much. Because I just want to be sure that we are still on the same platform if I'm saying ADR. So now, the third mechanism of ADR is the arbitration. Arbitration. So, when you talk about arbitration, anybody to define arbitration for us, please? Anybody to define arbitration for us? Anybody to define arbitration? Anybody to define arbitration?
In arbitration, there is the independent parties. That is, like 3 of them are involved. So the independent party is the arbitrator. he tried to resolve the issue.
Thank you very much. Now, in French, we call something arbitre. When there is football match, we have arbitre in the field, the referee, the referee. So the in referee in French is called arbitre. So these people, listen, they are the one that take final decisions for final decision or binding decision. Understand? So she said a third party. If two teams are playing, a third party is there that is not supporting both. So arbitration is the submission of a dispute to one or more impartial persons. Submission of a dispute to one or more impartial person. So the arbitral panel, they are there for a final and binding decision. Listen, so the arbitration submission of a dispute to one or more impartial persons, so involving an impartial person. Now in international law cases, they have the permanent court of arbitration. Yes, sir. They have the permanent court of arbitration. That is, they are impartial. Son, they are there to resolve dispute. When there is dispute between parties, the arbitrators or the permanent court of arbitration, they comes in to find a final and a binding decisions. Listen, so the arbitrator, they are not supporting the party. They are not supporting any party, because for arbitration even to exist, they will require consent. The consent between the parties. Understand? So the both party need to give consent, either through treaty or arbitral agreement. So if both parties does not give consent, and arbitration cannot be involved in most cases. Understand? So the fourth mechanism is a conciliation. Conciliation. So conciliation is where a third party will be asked to investigate the dispute and propose a solution that the party may accept or reject, because you cannot force them to accept it. Listen. So is the process whereby we are involving a neutral third party or commission to investigate the dispute and propose a solution that and give to the party. They may accept it or reject it. In arbitration, it provides a binding decision. Understand? But in conciliation, it does not produce a binding decision in conciliation. Understand? In arbitration, they provide a binding decision, but in conciliation, no binding decision. So conciliation is usually useful in disputes involving complex factual and legal issues that require experts to investigate or analyze. So conciliation will only occur when you need experts to be involved for investigation and analysis. Listen, after conciliation, we have a neutral evaluation. Neutral evaluation, when we talk about the neutral evaluations, listen, it's still, how do you call it? The neutral evaluation is a process whereby the neutral party examine evidence that both party bring in, listen to the party position, and provide an evaluation of their case. Listen, so it's like two countries fighting or two countries having crisis, and they both have the evidence, they both have the argument. A neutral evaluation is going to listen to them. After listening to them, bring out, how do you call, an evaluation of both party, how do you call, argument or evidence. So evaluation is usually simpler and less costly than litigation or arbitration. Listen, they mostly use that one. They mostly use that one in the preliminary stage. So they use that in the preliminary stage so that it helps both parties to understand the strengths and the weaknesses of the position before they can proceed to either higher place or court cases, understand, or formal dispute resolution case. Understand? So the sixth one is the restoration of justice. Restoration of justice. So when you talk about restoration of justice, is restorative justice rather. Restorative justice is primarily a procedure to address criminal action and involve creating a process that focuses on the need of all stakeholders and including the victims involved. The victim involved, the community, and the offender. So I said the restorative justice is primarily a procedure to address criminal action. Listen, procedure to address criminal action. But when you want to address this criminal action, you need to bring in all stakeholders. I want to talk about all stakeholders, the victims, the offender, the community. Listen, you need to involve them when talking about their case. So in the context of international law, listen, in the context of international law, I want to take the case of Ivory Coast in 2010. Ivory Coast in 2010. So they took the president of Ivory Coast, the former president, not the current president, the former president. They took him to ICJ, International Court of Justice. They took him to ICJ. After they took it to ICJ, they have to call on all the people involved that was affected in Ivory Coast. They took them to the court also to testify against him because people died after the election. They killed people, and the ex-president was accused of causing the atrocity. So they have to involve the victims. They involve the current president of Ivory Coast. They involve the former president of Ivory Coast, and they also involve the victims to come. Listen. So this process, the restorative justice, is not only to punish the perpetrator, but is also to rebuild the society. Because the former president of Ivory Coast have to use 10 years. They give him 10 years imprisonment punishment. Listen, so it's just to restore dignity to of all the victims involved and to create sustainable peace in the society. So he did 10 years. After 10 years, then they now release him. After releasing him, after 10 years, he did another 2 years before he was able to come back to Ivory Coast. So in essence, the ADR, we've mentioned about a negotiation, mediation, arbitration, restorative justice, and the like, neutral evaluation as mechanism of ADR. What is the advantage of ADR in international law? Advantage of ADR in international law. It's an advantage of ADR in international law. One thing you need to know is that the ADR offer significant advantage. And one of the advantages of ADR is that it depends on the consent of both parties. That is, before any method is put in place for resolving dispute, for an alternative dispute resolution to be put in place before between any disputing countries or parties, you understand? The consent and the good faith of both parties have to be put into consideration. If one party or both parties are unwilling to participate in good faith, understand? Or if the power is asymmetric in nature, that is, the stronger party want to use force on the weaker one, the ADR will not hold. An alternative dispute resolution will not hold. But if the alternative dispute resolution now hold, it may produce agreement that are unjust and unenforceable. Listen. So usually what we notice is that in international law, in international relation, what we notice is that those powerful countries, they use their power on the superiority to impose unfavorable terms on weaker countries or states. Listen, but most time, this weaker country also reject the decision. This is the case of Iran. Listen, they want Iran to accept what they want, but Iran is rejecting them. Iran is rejecting what they are proposing. Iran also wants them to support. I mean, no, not to support, to follow their own decisions. Listen, that is number one advantage. That is, both parties have to give their consent in good faith. So they have to give their consent. Number two advantage of the ADR. Number two advantage of the alternate dispute resolution or alternative dispute resolution is that it is non-binding. Understand? It is non-binding. Most time, non-binding ADR. Understand? Non-binding ADR, because some of the ADR we mentioned, they are non-binding. So some non-binding ADR, understand, they may fail to produce a sustainable resolution. Understand? Because we said it is non-binding, which means that they can agree or reject this decision. Understand? So if a party or both party lack the willingness to agree, then that means there is not going to be a sustainable resolution. So we've had cases whereby some party will reject a decision. Listen, we've had the cases that parties are going to reject any decision, and it happened. Let's just take Nigeria. Let's leave international relation. Let's take Nigeria. If they take how do you call it? You look at APC, PDP, ADC, and the other party, they are going to court. After court, they go to Supreme Court, they go to appeal court. They are not they don't want to agree on decision. So sometimes decisions are binding in this case of PDP and APC, but you can still appeal some decisions. In the case of international relation, decisions are not binding. International law. So in the case of international law, decisions are non-binding. When it comes to mediation and conciliation, they are non-binding. So in mediation and conciliation, they can accept and they can reject. It depends on them. Listen, that is the second advantage of this ADR. The third advantage of this ADR is that there is usually confidentiality of the ADR proceeding. Understand? There is usually confidentiality. Although it's an advantage, but some people count it as a disadvantage because they want to see transparency. They want transparency, but because of confidentiality, listen, transparency is not into place, and public accountability also is not into place. Understand? So, which means that there's usually secret due to confidentiality of the ADN. There's usually secret negotiation and agreement. Understand? Secret negotiation and agreement. That is also a principle of diplomacy. Everything is with confidentiality. There are some things that they do not expose to the general public. So, secret negotiation and agreement is also an advantage, but it may undermine the ADR process. Listen, it may undermine the ADR process. What is an advantage of not exposing the process they use to come into a resolution? So the fourth advantage, let me just leave it at 3. You can try to Google out the advantages of ADR. So our time is too small. I'm looking at the time. So in conclusion, what we need to understand with the ADR is alternative dispute resolution or alternate dispute resolution. We should know that is just like a component of international law framework for peaceful dispute settlement. That is how they can settle dispute in the international system. That is the ABC to the Z of how dispute is being settled. Understand now? So from negotiation to mediation to arbitration to restorative justice, they provide a platform of how dispute is settled internationally. But you need to also understand the significance of this ADR. Understand? You need to understand the significance of the ADR, that is the respect both parties need to have for each other, the consent. Both parties have to give their consent. Listen, and both parties are not forced to accept the decision or reject it. They can accept willingly and reject it if they want. Listen, so, but in the international system, for peace to be restored, listen, no single ADR is used. No single approach is used. You need to use combination of different ADR. Listen, negotiation remain number one in any process. Negotiation remain number one. Listen, followed by any other method that is used that you think can solve the problem. Son, so this is about the question about the ADR. We'll treat the last question. We'll treat the last question, and then we are going to call it a day with the last question. The last question, I want to look at the last question. Look at question number 3 of the first past question. What's the question number 3 saying? Question number 3. Anybody? Anybody? Somebody should read the question number 3 for me of the first past question.
Explain with relevant examples the different sources of international law.
The sources of international law. Sources of international law. Understand? So if you look at that question also is common. Sources of international law. Where the international law come from? Where did it derive its source from? It's an international law. The sources. That question is a straightforward question. Understand? So one thing is, some people will say we have primary source and secondary source. Listen, we are going to treat that one. We'll not look at other questions, but there are repeated questions also, sources of international law. So we are going to look at the primary source of international law and the secondary source of international law. Listen, so international law does not just come in a bloom. It passed through some procedure, like some things were put in place before international law came into consideration. Understand? So sorry. So international law. So number one, we primary sources of international law. We will not talk too much on that one. So number one primary source of international is international conventions. Number one, international conventions, or you can say treaties. I said international convention or treaties. So treaties or international convention, they are the most important and most frequently source of contemporary international law. So sometimes you can call them conventions or agreement or pact or general act or charter or covenant. So the fundamental rule governing treaty is the pacta sunt servanda. I mentioned that one earlier. So pacta sunt servanda is a Latin word. Repeat. Pacta is P-A-C-T-A. P-A-C-T-A. Pacta sunt S-U-N-T. Servanda S-E-R-V-A-N-D-A. So pacta sunt servanda is a Latin word. Understand? That mean agreement must be kept. So it has been written in Article 26 of the Vienna Convention of the Law of Treaty, and that one is regarded as the oldest principle of international law, which means that treaty that are sometimes bilateral between two countries or states or multilateral, they must be respected. So the multilateral treaties that involve many countries, many parties, they are significant source of international law because they reflect a consensus agreement of international community. And when we say international community, we are mentioning that all the states involved in that particular organization or international organization. Listen, when you look at the United Nations, organization, they have 193 parties. So imagine that 193 countries, they sit down to talk about something and they agree on something. That thing automatically become a source of law. Listen. So anything they discuss at the United Nations Charter and all the countries agree, the majority agree, or anything they discuss, anything they discuss in Geneva Convention or the Vienna Convention on Diplomatic Relations, it becomes a law. So treaties is number one primary source of international law. After treaty, we have international custom. International custom remain the second primary source of international law, as it has been identified in Article 38, Section 1 of the International Court of Justice Statute. Listen, so when you talk about custom, we make reference to two things. When we talk about custom in this context, international custom, we make reference to two things, two elements. Understand? Two elements. That is the state parties and the opinio juris civis necessities. I will explain. The primary custom is the material element, which is also known as the objective element. I shared the note with you. You can see the note with you. So when we talk about material element, we mean the practice of the state. Understand? The practice of each state, the behavior, the kind of behavior, the generality of the behavior of each state. What is being repeated consistently. So the custom of a state that is majority, an international custom, can be turned into an international law. It can be a source of international law. Understand? The second one, the first one I mentioned, the objective element. The second one is the subjective element. Understand? The subjective element is a belief. Understand? The belief people have on the objective element. Something that it is a practice in our country, for instance. Not anything that you think is a practice in our country, as it is in our country, they are doing it in many countries. They are doing it in many countries. Understand? Let me just give you an example now. In UK, today is Monday. I'm not working today. They call it bank holiday. The UK has bank holiday. Understand now? They have bank holiday most times. And bank holiday is being exercised not only in the UK, it's been exercised in most European countries. It's been exercised in most European countries. So last month there was another bank holiday. This month there's a bank holiday. It's been exercised in most countries. Listen. So anybody that work on bank holiday get double paid. That is a practice. If you work on a bank holiday, according to the labor law, you get double paid. So that is a custom in a European country. So this kind of custom can be an element or a source of an international law. You understand? So the custom of people, the material custom and the subjective custom, the subjective element and the objective element of custom can be a source of international law. Can be a source of international law. So the subjective element is the psychological aspect. The subjective element is the psychological aspect. That is the belief we have in the objective one. Listen, the objective one is the material element, what we can see, what we do consistently, the behavior we do consistently. Listen, I give some example in the note I share with you. You can check them, the examples. Listen. So the third source of international law is the general principle of law. General principle of law. So the general principle of law, they are drawn from our common law, common legal law. Understand? They are drawn from our common legal law, the civil law, common law, Islamic law, understand? Customary law system. So any law that are there, they are also part of the international. They are also source of the international law. Understand? So the general principle of law, they are drawn from the common legal traditional law. So what is our common law? Either the civil law, the common law, the Islamic law, the customary law, they are also involved in the general principle of law. Understand? So that's about the primary law. The secondary source, that's the primary sources. The secondary sources, we have the judicial decisions, we have the teaching of publicists and other relevant sources. So we are going to call it a day today. We are going to call it a day. You can check the notes. Check the note for other examples. I put some example and explanation in the note. You can check the note. I wanted to stop by 8:30. I have a lot of what to do. So if you have questions, I know we have some lawyers here. We have some law experts here.